Hello, my name is Mr. Liu, and I'm a high school teacher at Jordan High School. Today, I will present to you a case study of Vizcaino v. Microsoft. This is a case of ethics, and labor ethics, business ethics, and it actually is something that when it happened and I participated, I was part of it, that the ramifications of this case law was widespread. At the time, Microsoft was the big giant in the room. And if this case would fall in favor of Microsoft, or in this case, in favor of the plaintiffs, that this would determine the use of independent contractors for the long term. Now, one of the challenges of this particular case is that Microsoft used what was then a common practice in business, something we called a long-term temp. And I like to call that an oxymoron. Seems odd to call somebody who is a temporary worker a long-term temp. At the time, Microsoft thought nothing of it. In fact, they had all their temporary workers sign a statement acknowledging that they were not, in fact, an employee of Microsoft, but they were independent contractors responsible for paying their own taxes to the IRS. Well, folks, let me tell you from personal experience, it will be the IRS that will bring down companies and individuals for that matter. In this case, there was something called the IRS 20-factor control test to determine whether or not somebody was an independent contractor or an employee. Today, those 20-factor control tests have been whittled down to 3 different categories, and one has to do with the behavior of the employee, when do they report to work, where do they report to work, and so forth. Then the next has to do with finances. How is the independent contractor or the employee paid? And finally, the relationship between the employer and the independent contractor. Again, you can't have something called a long-term temp because just by nature, if somebody is going to be working for you long term, then the likelihood of them behaving in certain manners, being paid in certain ways, as well as the relationship changes over time. There's really no skirting that issue. The IRS 20-factor control test is based on common law. And as we used to say to our managers at Microsoft, if it walks like a duck, if it quacks like a duck, it looks like a duck, guess what? It's a duck. And so in this case, we're trying to determine whether or not we should use an independent contractor or a hire person as an employee. Now, one of the reasons why employers like to avoid a fully benefited employee is because it is costly. In fact, I had one conversation with the general manager within the company of a very large division. And he asked me, have you ever managed a P&L? And I was embarrassed to acknowledge at that time that I had not. I had managed a lot of different things, but I was never responsible for a P&L or a profit and loss statement. And what he suggested to me was that if I had that experience, I would certainly understand that it would be prohibitive of him to convert his temporary employees to full-time employees. The results or the economic outcome would be that his division would be losing money. and he simply could not report a loss. And those are some of the facts. And I will tell you that my role as a human resource consultant at the time, we were known as workforce planners, is my job is to inform the managers about the inherent risk involved. And it is my job to help that manager mitigate risk. In other words, reduce risk. But we know in business that businesses carry insurance for a particular reason. They carry insurance because any large business is likely going to be caught doing something maybe inappropriate, and they need insurance to cover their losses. And this is just part of business. And part of being a manager is just understanding how to manage and mitigate risk. Well, so in this case, this particular division manager, I warned him, I advised him, and ultimately, though he must be accountable for whatever decisions that he was making with regards to labor. Now, this case was a big case. Vizcaino v. Microsoft settled in the end for almost $100 million. Now, the plaintiffs, unfortunately, they had to pay their attorneys somewhere in the neighborhood of $27 million of the $97 million settlement. And then the rest were going to be divided up between somewhere between 8,000 and 10,000 former temporary workers who were entitled to a portion of this settlement in this class action lawsuit. Once again, known as Vizcaino v. Microsoft. Once again, this particular case law set precedent on how employers are going to manage temporary workers in the future. So, what are some of the challenges? What are some of the costs involved if an employer hires somebody full-time, fully benefit versus a temporary worker? Well, if it is a temporary worker and it must meet certain requirements, then the employer is not responsible for paying employment taxes such as the income tax, Social Security benefits, Medicare benefits, unemployment tax, all of these additional costs that become quite a burden to the employer. And in the case of Microsoft, there were enormous amount of benefits also, such as an employee stock purchase program or an employee savings program. And these also would be very costly. And for that reason, it was a normal practice at the time for employers to identify contingent staffing positions. These are temporary workers. Well, the way that this caught up eventually to Microsoft is that the IRS, or the United States Internal Revenue Service, identified these employees, these temporary employees, as full-time workers. In other words, they did not pass the smell test. They lost when it came down to the 20-factor control test. Again, today it's narrowed down to 3 categories: the behavior of the worker, the finance or how that worker will be paid or compensated, and finally, the relationship between the employer and the worker. And when it came down to that, Microsoft could not convince the IRS that these temporary workers, these contingent workers, were not, in fact, their own employees. So Microsoft did have to settle. And as a result of that ruling, plaintiffs, led by an individual, Vizcaino, filed a class action lawsuit against Microsoft for back benefits. In other words, they said, if the United States government says that we are your employees based on tax law, then we should be entitled to back benefits. In other words, we should be entitled to medical benefits, in stock options, a number of different what's called employee or employer welfare programs. And so ultimately, the judges initially ruled against the class, and Microsoft won, but it was appealed, and then it was later determined again that these temporary workers were in fact Microsoft employees and that they would be entitled to back benefits. So, difficult decisions that must be made, nevertheless real. And whether it's this type of scenario or something similar, these are difficult questions that you and other future leaders must address. They're not always easy. It's not always black and white. Businesses do make economic decisions, and they do take on risk. And once again, that's why we have something called insurance. So the real question for you is it ethical to pay somebody off the books, if you will, as independent contractors when in fact you are managing these employees? They report to your same workplace. They do the same work as your other full-time employees. Like I suggested earlier, if it walks like a duck, looks like a duck, and it quacks like a duck, it's likely a duck. How would you roll in this case? If you were a leader, what would you do? How would you make sure that your management and leadership team embrace the correct employment practices? I will tell you, most business leaders will say the most difficult thing in running a successful business are human resource issues. They're not easy. And frankly, I think many employers would love to just say, they're not my employees, and just kind of wash their hands from those difficult HR decisions. In this case, plaintiffs, about 8,000 to 10,000, had to wait over 12 years later to finally receive on average $8,000 to $10,000 as part of their settlement. So you decide, what would you do? What would you do in similar situations if you knew that you were possibly skirting the law and that you were maybe working in a gray area? How would you recommend to your shareholders, how would you recommend to your investors that you proceed forward, knowing that it could cost you a lot of money? This is Mr. Liu. This is your case study. It is about ethics. It is about workforce practices. And I will tell you that it wasn't pretty. And I will tell you from my own experience that there are plenty of people in leadership in large corporations who would say that if you work in human resources, you're simply overhead, and we really don't need to listen to you. So you figure it out. You make your recommendations. What would you do? How would you determine, based on this 20-factor control test or these three categories of behavior and finances and relationships, how would you decide the right thing to do? Good luck.